Parents.
Hi, I'm Karen Mankowski. I'm the supervisor here for many services, but your interest today is the adult mental health team that we have at the county and the pre-petition screening process. The pre-petition screening process is the first step toward civilly committing a person in the state of Minnesota. We often refer to things in alphabet soup, so when I say PPS, that means pre-petition screening. And also it kind of encompasses the whole process that we're talking about. A request for pre-petition screening can come to us in a variety of manners, but typically it's from some type of community setting. So it could be that the individual's in the hospital, maybe discharging from some other setting where they're feeling like the person is not quite stable enough yet to return to complete independence. Can be that a family member calls in a pre-petition screening request as well. Requests are sent to what we refer to in the county as protection intake. And that phone number for protection intake is on our website, but it's also our general office number that goes to a live switchboard person. So that's our 457-6200 number, and a person would be asking for protection intake. Another manner of which we receive requests are through law enforcement. When they've been out on site with an individual, have ascertained the individual is in need of some protection from themselves, in need of a higher level of support and services, typically when they are not voluntarily engaging in those. And so an officer who is working off duty, will be off duty during our business hours, would include that request within their police report that's sent to us. We review our police reports that are sent to us every day, and we do look for that language in there where an officer might have said that meeting with that person rose to a level that the officer feels like the pre-petition screening should meet with that person to assess their safety, their risk of harm to self or others. So we receive the intake. We make phone calls back to that caller if we need to. We review the police report if it came that way, call hospital staff. What we're trying to ascertain is, does the request meet that level for us to be able to go out and meet with a person when they're not voluntarily asking to engage with us. Civil commitment pre-petition is typically not a voluntary service. If people are willing to engage in voluntary services, we have a whole array of other services within the county and the community to work with that person toward increased stability. So we're looking for the person to be at risk of harm to self or others, and it's imminent risk of harm to self or others, or due to their mental health or chemical dependency, being unable to meet their basic needs. That's the legal threshold. And Paul will go into some more of that after I go through our process. So we get the request every week at the county, and in most counties, there's a pre-petition screening team. Some counties have a permanent team of staff who have that function, and in a county our size, we have a staff team that rotates through that. So every week we have 2 staff that are on as our pre-petition screening team for the week. One person's primary, one person's secondary, and they would be the group that are meeting with the person face-to-face. When our staff go out and meet with an individual face-to-face for the purposes of a pre-petition screening request, it's important for those who might make those requests to be aware that we currently go out on those requests with law enforcement. Again, we're being told that that person is presenting some imminent risk of harm to self or others, or is in some other way unable to meet their needs and may be in a dangerous state of mind. We are not going to have our staff go out unsupported, and also it's that we're supporting law enforcement when they go with us in a nice partnership. Now, so we do take law enforcement out with us. When we go to a hospital, if they're there, or in another safe setting where someone can speak to us about the state of mind of that person, then we do not need to take officers with us. It's for the safety of the unknown for that person as well as everyone else involved. When the team goes out, they interview the person. They're given their rights. I have Tessa Logan on here. She can speak a little bit to how that interview goes. but we do meet with that individual, interview with them, and then the staff that are assigned as the pre-petition screening team, that 2-person team, comes back, and then as a group, we team that and we assess the risk of harm. We assess what they found in meeting with that person, how willing that person is to engage in other services, how able they actually are to engage in those services. They might be willing to do other opportunities for that person, as civil commitment is very much involuntary, is very much court involved, and can have some other consequences for a person depending on their career, lifestyle choices, things like that. So we really try not to proceed if there are other options that would meet the needs of that individual. We make that decision as a team, and then our recommendation is brought forth to the county attorney's office. So that's that part of things. Tessa, do you want to chime in just a little bit on what you do when you go out as a team interviewing the person?
Sure. Thanks, Karen. So yeah, when we go out, we'll meet with law enforcement and we'll kind of discuss the situation if they don't have any police incident reports and they haven't had involvement with that individual historically or currently. So we'll kind of give them some information so that they can be aware and help support us the best as possible. Then we'll, knock on the door, and a lot of times we do come unannounced. And I guess it depends basically on the situation, if it's better to call ahead or if it's, that we're just showing up unannounced. A lot of times the PPS clients will open the door and depending on their state of mind, might shut the door, and we could proceed with the information that we have without interviewing that individual. But it's really important that we have that conversation with that person so that we can get their side of the story. Because sometimes when we get requests from like family members or other community members, they might not have the entire story. And so it's really beneficial for our team to get as much information so we can proceed if we need to or not proceed. Typically, we introduce ourselves and let them know what our civil commitment process is, what their rights are, because they do have rights. We'll go through all of those and we'll let them know if we did proceed, that the information that they provide to us could be used in court. Then we'll let them know that we'll also be obtaining documents or other information from collateral, they're like collateral people. And then hopefully the conversation goes well, and we can gather a lot of information from that client and their surroundings. And then, like Karen said, we'll bring that to our team and we'll team that and decide to move forward from that information. Karen?
Yep. I think it's important to note that the decision to proceed or not proceed is not made in isolation of just the screening team, that the two people are going out, they're bringing that information back, they're sharing it with a larger group, we're sharing that with the county attorney's office, and collectively we're doing our best determination in regards to the well-being of that individual that we interviewed. I think it's also important for community members who have concerns regarding a family member to keep in mind that there are wonderful arrays of voluntary services in the community that your family member could engage in. This is involuntary. It's one of the most extreme services that we can place upon a person. It does a great thing. It helps many people stabilize, return to the community. What we use as our goal when we're proceeding with civil commitment, our outcome that we're seeking at the end is the person at least a little better than when we met them? Are we leaving something improved in their life, something improved with their mental well-being? Are they better able to function? Are they able to go back to their apartment? Whatever it might be. When we bring forward a petition and it goes to court, and again, Paul will speak to that a little bit, there's the possibility of 3 outcomes. If there's more, they'll cover it. But the court could say it's not enough and they dismiss it. The commitment is not granted. Could be that the outcome is the person maybe has stabilized enough, is willing to engage in some services, and we want to give the opportunity for the least restrictive, most appropriate services for everyone in our community. So if they're at this point now willing to engage, and maybe they weren't earlier on, or for some reason we're not sure that they're actually capable of following through with what they are stating, the court may agree to a stay of commitment. Otherwise, there is full commitment where the person is admitted somewhere for stabilization of their mental health, chemical dependency. Commitments can be mental health, chemical dependency, or both. So then they're sent to engage in some more therapeutic services with the resolution of stability, and then returning to the community. At times, we do need to ask for a extension of that civil commitment. Sorry, I couldn't find the word. In the event that the person hasn't had an opportunity to be supported in their return to the community. So say they're fully committed, and most of that 6-month time frame that we might have for the commitment is spent in a hospital setting. We've not yet had the opportunity to support that person back in the community or through that transition back to the community. And again, we want to leave the person better than when we started with them, even if it's a little bit. So we want to help them back transitioning to the community to assure that their stability can continue, that they're getting connected to the right services back in our community and have the choice to engage in those or not. So we would do an extension of a commitment on some of those individuals to support that process. Anything else I missed on our end of things, Tessa?
No, I don't think so. That sounds like it was an accurate representation.
Yep. And so again, just remember when you're calling it in, if you're not looking for that most restrictive, most intrusive response, you might want to work with your family member, or law enforcement might want to work with the person that they're meeting with on the potential of calling our office for voluntary services. And if the person is willing to engage in voluntary services, it's that same phone number I gave earlier for protection intake, but at that point you're asking for services, and then they'll connect you to what we refer to as service request intake. So typically we're dealing with the public coming in for voluntary services, which are service request intake, or involuntary services, which is protection intake. Kayleen, any questions you want to field, or how do we do this next step?
Sure. So Christy asked me to field any questions. So if anybody has a question, feel free to unmute yourself and ask that right now. Just an update on Paul's schedule. He's actually in court right now. I'm not sure if it's on a commitment hearing or not, but is tied up a little bit. So we'll take some questions now, and then if I'm able to screen share, I'd like to share some resources about civil commitment with everybody here, both for information purposes and to kind of give Paul some time to join us. So if anybody has a question, please unmute and go ahead and ask.
I have a question. So I came in late, and I just came in at 10 o'clock or 2 minutes after, and someone was already talking. So I was a little confused of where things were at that point. So is it my understanding somebody from the screening team, the first step is somebody from the screening team goes to the home to interview, or did I miss something?
Well, we receive that information, yes. So we receive the request, and the team is assigned, and they go out. They might be at the person's home. If the person's in the hospital, they might go there, or if they're in a community setting, perhaps they were engaged in treatment and then decided that they weren't going to follow through with that well, or they just aren't stabilizing well, and that team serving that person might be seeing the need for this. So it hopefully we're seeing the person in the hospital, because if they are at that level of imminent risk of harm to self or others, we really want to ensure that they are being supported in their mental well-being and being taken care of and attended to and protected from any harm they might create or cause to themselves. So ideally, they're in a hospital setting, but that is not always how it is. Often they can be in the community.
So to start with, it would be a family member or a therapist or someone working with this person decides that they can't follow through on their help, or they're not getting help, that they really need help, and that's where the request is made?
Not lack of follow through with help. Anyone has the right to choose to engage or not engage in voluntary services. This is for a person who is seriously presenting an imminent risk of harm to themselves or others, or due to their mental health or chemical dependency, is utterly and completely unable to meet their basic needs.
Okay, gotcha.
So it's not those who are seeking voluntary services or may choose or not choose. Everyone has the right, even persons with chemical dependency and mental health have the right to make some poor choices and maybe not live at the same lifestyle that someone else might choose for them, that doesn't present them at an imminent risk of harm to self or others or being unable to meet their basic needs. It's just maybe not what that family member would desire for that person, but it's not at that level. So it's very much important to remember that really for us, this is the most restrictive, most intrusive service. And
so gathering the information helps you to decide that, because, you know, like you said, what if a family member is not agreeing with how this person is living their life, but they are doing some things to help themselves. And so that gathering information, is that the part where you can figure out whether that's, you know, they really are at imminent risk, or if it's just a family issue? Or
well, some of that is for protection intake, some of the questions that they ask during that process, if it's called in from the community and not from a hospital where a doctor is signing supportive commitment, then protection intake will review some of that with the caller, tell them of some other resources in the community, advise them of what our process is, so they really do get that information at that call to understand the seriousness and the nature of which they're calling in. And do they really want that to rise to that level or not? Sometimes they'll go over how to talk with your family member about potential voluntary services, how to make those offers to that person. They might encourage them, if you try these and it doesn't work and you really still feel that, or you feel that this person is that level, maybe you want to try the conversation first, maybe you call us again later. So we do try to provide that education, because rarely do I let my team not proceed with going out on that interview. So we're showing up at their house and the first sentences out of our mouth are happy introduction, and then needing to tell them what their rights are in regard to a civil commitment.
So your referrals come from doctors mainly?
Ideally, that would be the perfect world, that they came from hospital settings where the person was or not was on a hold, and someone else has assessed that they meet that level of care, that they're at that risk level. But our experience is that a large number of them come from the community as well as from hospital settings.
Okay.
Yep. And I think it's also kind of important to note that if a family member is making a report about an individual not being able to meet their basic needs, it has to be a true report, because it's illegal to make a false report on an individual. Mm-hmm. And when we talk with our family members that are making the report, you know, of course we have to remember and remind them that, you know, there is HIPAA. So if we're working with somebody, we can gather information. We don't share information. And it looks like a question also about like when is a court attorney appointed. I guess when we look at the civil commitment process, I sent Karen a flow sheet, and maybe she'll send that out to Christy, and that kind of describes the commitment process. What we'll do is we'll interview the individual, and then, like Karen said, we'll team with our entire team, and we'll review all the documents and collateral information to decide if we're going to move forward or not. At that time, we'll work on the petition and a narrative that we send to the court, and then our county attorney will review that and agree that we need to move forward with it or not move forward with it. I guess it depends on where the client is at. If they're in a hospital, then they have, I think Paul is at 7 days or it's 72 hours from the preliminary hearing. So once we submit those documents, that person will be appointed an attorney. And then within 72 hours, then we'll have the first hearing. And then after that, I think there is 14 days until the second hearing is held, unless there's some other circumstances that prevent us from having that court hearing. And at that point, the court would make notice of that and send out a letter saying that for whatever reasons, this court hearing has been extended.
I can add to that as well. So when court administration gets the petition, and sometimes I think they even get advance notice, and Paul can, you know, speak to that. The court administration has a team who works on probate and civil commitment matters, and they have a list of attorneys locally that handle those matters, that have experience and are approved to handle those matters. And so what they do is they send out an email asking, indicating that there is a hearing to be held, asking who would be available to take that hearing, and typically within a couple of minutes, an attorney is located, they're given the information, and they're expected to reach out to that person before the hearing. So I think the short answer is it is at the point at which the petition is filed. And Paul, if you want to weigh in on anything I might have misstated or add to it, please feel free to do so.
No, that's accurate. Once the county does give the county attorney's office, we do give court administration a heads up that we'll be filing a petition. Once we file a petition, shortly they appoint an attorney for the respondent. So it is a pretty quick process. We try to give them forewarning so they can get things worked on their side.
And then we do have a question in chat. What does it take to be considered imminent risk? In most cases in Winona, the hospital will not keep or put individuals on a mental health hold simply because they do not have a mental health unit, no matter how much they are in need of inpatient services. So would somebody like to field that question?
Sure, I'll give it a try. It is true that we do not have a formal Department of Behavioral Health here in Winona. The emergency room, though, can assess that a person is in need of hospitalization, either voluntarily or involuntarily, and they do have the ability to search for appropriate beds in other hospitals for that voluntary or involuntary stay in a behavioral health unit. If they don't find that person to be in need of that level of care and that person is released to the community, and the family member still has concerns and they're feeling like there's that imminent risk, that's why I say in our county we do get a large number of calls from the community and not just from the hospital. And that's why we do proceed on requests, so that when we go out and meet with that person, we can, if we don't have enough to rule it out right away from the intake and that conversation with the caller and give them other ideas of what might work for that person, and they're at that concern level, when the intake comes from protection to my team, they are setting up that interview. Because the person isn't on a hold, we're not necessarily getting out there within a very precise amount of time, but we are getting out and interviewing that person still. And through the course of that conversation with them, we'll be gathering more information and details regarding the imminent part of risk. It's really hard for a community member to decide that themselves. So if you have that level of concern, we just really do caution people to go ahead and err on the side of safety, err on the side of us getting in contact with that person. If you're that concerned about your loved one, your family member, your neighbor, your community member, having us go out and meet with them might upset them some, but also it's a great opportunity for us to tell them about resources in the community that they may benefit from if they so chose to engage with, if we didn't need to end up proceeding with them. So on our end, and Paul will speak to it a little bit, we have a threshold legally to proceed, but we can go out and do that interview, and that's when we're gathering information to really decide, does it meet that imminent or not? Are they really presenting a serious risk of harm by being unable to meet their needs in their home, and what does that look like? So it is a hard one to do on your own, to decide on your own for imminence, and that's part of our assessment process when we're doing that interview.
Just to add on to what Karen said, as she stated, there is a difference between calling in a PPS request and doing the initial investigation, and then when we make the decision as whether or not to file a petition with the court alleging the need for civil commitment. So I agree that if there are concerns, it's usually the best bet is to reach out, and then we can make a determination later down the road instead of trying to make the complex decision by yourself whether or not the dangerousness threshold is met.
And then I see a question in the chat for the number for our agency again. And then to reach through our switchboard, the phone number is 507-457-6200. And those are really for service requests and protection requests, child protection, adult protection, adult protection goes through the state now, sorry. So child protection, pre-petition screening. If you're looking for our other services like income maintenance, child support, those kinds of things, we have a really excellent setup phone bank where if you called our 457-6500 number, you'd be into those types of services. But for switchboard and the direct engagement with us for services or pre-petition, it would be the 457-6200 number.
Thank you. Do we have any questions before Mr. Ellison starts talking about the legal aspects of the commitment process? And there will be time afterwards to ask questions, but any other questions either in chat or you can unmute yourself? Okay, I'm just going to read this. We have a question in chat. My understanding was that a crisis response team was a place to reach out to before the police and emergency room. When I did have to call them, they suggested the emergency room because the team was too far away from Winona. What exactly is their role? So you folks are not on the crisis response team. Do you want to field this question or do you want to redirect this? And I can let Christy know about this because that is run through Hiawatha Valley. Anybody want to take that question?
Well, I think for the crisis response team, for the most part, I mean, it goes to a phone bank and then they decipher if that person needs that team to come out and respond. And a lot of times I believe that the police do go along. I think, Linda, you're on here, and I think you're on the crisis response team. Could you answer that?
Also, I just want to add too that the team could be out on another call, and we only have so many bodies working on the crisis response team and in serving our community. So if they are out on another call and meeting with an individual in the community, it is possible that they are advising you to seek the safety of that individual first because they are unable to respond on site in that timely of a manner. But go ahead, jump in, Linda.
Yeah, so like Tessa said, there's an original triage when it comes to calling crisis, and then they pass it along if they feel a mobile response is necessary to the appropriate hub. I'm not sure what may have caused the situation for them to say they were too far away. That's not typically something that we would say or come across. But it's basically to be, a first response to a mental health crisis. We can and do go out with police officers. Police officers call us to go out if it's a case that they feel is more a mental health crisis versus a legal issue. And our goal ultimately is to keep people out of the hospital, to find a way to help them stay safe in their homes. And Christy can always jump in too, because she's very much involved with us as well.
Christy had to leave, so that's why I'm taking over the facilitation of this. And again, there was a presentation earlier where this was discussed, but all good questions, and I agree Christy would be a good one to ask. I'm sure she'd field an email or phone call about any further questions on that. Do we have any more questions right now before we get into Paul's presentation? Going once, twice. All right, Paul, if you want to go ahead and talk about the legal aspects of the civil commitment process, we'll let you go ahead.
All right, thank you. So I'll just kind of start with a broad outline, and then of course, if people have questions or want me to give greater detail, I can certainly do that. So when a pre-petition screen request is called in, I'm copied on those emails, so I am aware. Once the investigators make the determination whether or not to recommend going forward with commitment, then the petition, a narrative, which is essentially the facts and circumstances supporting why commitment is appropriate, are sent on to me for my review. Then we get those documents filed with the court. So if someone is in a hospital setting, I believe I heard Tessa mention this when I joined, they can be placed on a 72-hour hold. So if law enforcement brings that person to the hospital, or if they voluntarily come to the hospital and then the hospital determines that a hold is necessary for that person's safety, it's a 72-hour hold. It does not count weekends and holidays. So if a person's brought in on Friday, that Saturday and Sunday won't count. To keep a person in the hospital after that 72 hours, there needs to be a court hold, a order issued by the court. So once that 72 hours expires, if we don't have a court hold, technically the hospital is supposed to release that patient, which sometimes can run into difficulties trying to get an order filed with the court and try to get something signed back as soon as we need to. Once, as Kayleen mentioned earlier, once petition is filed, the court works on getting a attorney appointed for the respondent. There are a handful of attorneys in Winona that, and one up in Wabasha that usually handle these commitment proceedings. Once the court hold is issued, we need to have what's called a preliminary hearing. And that hearing is essentially the court reviewing whether that individual needs to remain in a hospital setting pending the final hearing. So the standard is whether that person is immediately posing a danger enough where that person needs to remain in a hospital. Sometimes the individuals don't contest that at all, and they simply agree to remain in the hospital pending the final hearing. Otherwise, it's a bit more contested. Let's back up a little bit. If a person is not in a hospital setting, there's a couple different options. If the county feels that it's necessary that this person is an immediate risk of harm and they need to be in a hospital setting, I file a motion with the court requesting that an apprehension order be issued so that law enforcement can take that person to a hospital setting. It is ultimately the court's decision. Usually the court will grant those because we're really not requesting those types of orders unless we feel it is extremely necessary. If we feel that the person does not need to be, the level of danger is not necessary or isn't high enough that the person needs to be in a hospital immediately, or we don't think we can meet that, another option is to simply file the petition and give the person notice, and then that matter is just scheduled for a final hearing. So there's no preliminary hearing because the person is not being held in a hospital. So once the preliminary hearing happens, or we just set it for a final hearing, the individual has had an attorney appointed. The court appoints what's called a court examiner. So that is an independent medical professional, a psychiatrist or psychologist who's licensed in the state of Minnesota, and they meet with that individual, review records, make collateral contacts with hospital staff or other involved persons, and they write a report and file that report with the court, and they make recommendations. Their main recommendation is whether they believe that the individual meets the standard for commitment, and then two, whether a less restrictive option could be appropriate. So at a commitment hearing, back up a little bit, there's a couple different options. So there's person who poses a risk of harm due to a mental illness. So it's not just that the individual has a mental illness. They have to show that either they're not meeting their needs, they've engaged in aggressive actions, either towards others or themselves. We get quite a few people who have made threats or attempts at suicide. That's kind of an example. Individuals who don't have necessary shelter or medical care, so individuals who are homeless, but may not be homeless because of a choice or economic means, but because they have been offered services or are just not in touch with reality enough to engage with services that get those people help. Of course, now that we're in April, it's a little bit different than when we had people spending nights outside back in December, January, and February. It can also involve significant damage to property. Maybe that's not as common in my experience, but that can be something to support it. The other one is a chemically dependent person. So a person who cannot basically manage their own affairs day to day because of their level of chemical dependency. So this can be alcohol, methamphetamine, any type of substance. That definition also falls for if a individual is pregnant and they're continuing to habitually use a controlled substance, then that person also meets the definition of a chemically dependent person. So then we get to the hearing. We do explore between the initial paperwork being filed and the final commitment hearing, we do explore if a stay or other alternative is appropriate. So if this person's been in the hospital, they started taking medication, they're doing a lot better, they're engaged with their treatment, normally we consider whether a stay is appropriate to kind of give that person some recognition for the effort they put in. And if we don't feel they meet the threshold for commitment at that time, then a stay is more appropriate, we can go with a stay. So if the matter is contested, and sometimes people don't contest it and agree to be committed, it is my burden as a county attorney, assistant county attorney, to prove to the court by clear and convincing evidence that the person meets the definition of chemically dependent person or person who poses a risk of harm due to a mental illness, and that that person is in need of involuntary commitment. I usually will call, if the person's in a hospital, I've been trying to get a medical provider to testify because they're working with that individual day to day. They can provide the most up-to-date information. I do usually call, well, basically always call the court examiner. The reports are quite detailed and helpful, and they are experts in the field. Sometimes I will call the pre-petition screener, the social worker. I've been trying to not do that as much, but that's other potential witness. So I'll put on my witnesses and then submit any exhibits to the court, and then the individual who potentially subject to commitment and their attorney have the chance to submit evidence and present testimony as to why they believe that a commitment is not appropriate in the matter. And the court has a couple different options. Then the court can either just outright deny the county's petition, and the person will not be committed. Second, if the court feels there's concerns but a stay is more appropriate, the court has the authority to order a stay of commitment. And then third, to order that that person be civilly committed. A commitment is for a period of 6 months, not to exceed 6 months on an initial commitment. There are reports, there's a 60, 90-day report that has to be filed with the court to update the court how that person is doing. If we don't, it's to protect against the case where if a person is committed and then 2 months down the line, they're doing remarkably better, and really we don't need a commitment anymore. It's to update the court on that information. Once the initial period of commitment is set to expire, the county can request that the commitment be extended for a period of up to 6 months. If the person, we see clients who have been in a hospital setting or in an otherwise secure facility for 5.5 or 6 months out of those 6 months, and they have a continued need for the support and the services of a commitment, we will file a request with the court that the matter be extended, and then that matter is set on for a hearing before the court on that issue. We do have, I don't know for this presentation if we need to get into the weeds too far, but if a person is on commitment for the full, so 6 months plus another 6 months, so that's a full year, there's slightly different statutory requirements for if we're trying to continue the commitment past that year mark. We need to file a new petition. For the purposes of this presentation today, I'm not sure we need to get too far into that. If people have questions about that, I can certainly answer them, or feel free to reach out to me at any other time. So that's kind of the basics of how commitments function. I'm, of course, here and willing to answer any questions that people may have.
So we had one question come in, Paul, while you were talking. The question is, can another person disagree with the commitment on their behalf, or would that be evidence they can't care for themselves? The way I interpret that question is, are other witnesses allowed to testify on behalf of the person subject to commitment to oppose the commitment? In other words, to testify that that is not needed?
Yes, the individuals usually be through the individual's attorney, which has been appointed. But if they have a family member, a friend, or whoever that has information they think opposes a commitment, they are certainly called to testify. They can testify. They don't have, I guess, an independent right if neither party calls them, unless the court would ask them to provide information. But in my experience, the individual's attorney would almost certainly call them as a witness.
And then kind of a follow-up question to that, can the person subject to civil commitment take the stand and testify on their own behalf and explain why they do not feel they need a civil commitment?
Yes, they can.
Okay, and that would be something that they would likely discuss with their attorney and prepare with their attorney for?
Correct. They discuss that with their attorney, and then it's ultimately that decision whether they want to provide information to the court.
We did have another question come in by chat, and that is, does the county ever request that a guardian or conservator be appointed to manage the person's affairs while they are committed?
We have done that in a couple different times. A person simply being under commitment does not mean that a person loses the ability, the legal right, I should say, to manage their property and their affairs. Of course, it's more difficult if a person is in a hospital setting and not in the community to manage some of those issues. So we have done that a couple different times. We also do explore whether, if we get a pre-petition screen report, it might be that we determine, well, this person already has services with the county to some degree, a guardianship and conservatorship, or one or the other seems to be more appropriate. So we may consider whether something like that is a more appropriate solution to the problem versus having a person committed. There's also a provision for a substitute decision maker. I can't recall ever using that in the 2 years that I've been handling these, but that is another option for if we need to get someone in place right away to help the person.
Also, individuals can look at the advanced directives for mental health, and they can have those signed and in place. That may help with some of the decision making regarding their choices that they would have made, which could help guide treatment, or in the event that they actually have a guardian and we're not proceeding, might help guide what they would have wanted to engage if they were able to give that consent, and the guardian could do that in place of that. So there are some mental health advanced directives out there also that individuals could take a look at when they're doing well and make their desires known ahead of time. So I just thought I'd share that as well.
And Karen, as a follow-up to that, perhaps you could try to locate a link to that and post it in the chat for folks. I know that we've talked about that in other contexts and somebody was able to locate that. Maybe it was Tessa, I forget. A follow-up question to that is, and this kind of alludes to something that Paul said, how frequently do you see civil commitments requests for pre-petition screening for folks that have stopped using their medications, so that they were stable, feeling good, stopped using their meds and became dysregulated? Is that a frequent occurrence?
It is a frequent enough occurrence, but also those could also be a large number where if they're willing to engage in services and return to their medications with support, that we can make those service offers to the individual and assess, are they capable of agreeing to do that and following through with that. So stopping medications, while it's a common occurrence, isn't always that we just proceed on it, but it is a thing that does cause instability for persons with mental health.
Okay, any other questions by chat or unmute? I'm going to attempt to share some additional resources. Oh, let's see. Tessa has posted the link to the Advanced Psychiatric Directive, which again could be a preventative measure for folks to have their wishes be known in the event that they do stop taking their meds or become dysregulated, that they've already specified this is what I would like to happen. So I'm not an expert at this, but I'm going to try to share some resources that may be helpful for folks. The first one that I'm attempting to share, maybe somebody can give me a thumbs up, is the Minnesota Office of Ombudsman for Mental Health and Developmental Disabilities does have a repository of civil commitment documents and reports. In fact, it is this agency that has also offered and will offer civil commitment training. So I've just clicked on the screen for that. I'm not able to see thumbs up. Can somebody just unmute and say whether you can see this screen or not?
Yep, we got it.
Okay, perfect. So I can share these links in the chat, but for anybody who's looking for additional information, you may want to check this out. There is a training brochure, so if you want some additional training, you can reach out to those folks. And then there are some very helpful and up-to-date documents. The civil commitment process actually changed fairly recently, so all of these things had to be updated, which is great. These are some good resources, fact sheets on different topics that we've touched on or some that we haven't. Additionally, NAMI, so NAMI Minnesota, a great website for people interested in this topic. They also have a civil commitment booklet, which I, as a person who does represent folks in civil commitment matters, have taken a look at and actually shared with some of my clients. It is pretty lengthy. It's 44 pages, very comprehensive. And in the past, we've been able to get, and you can't see that, but we've been able to get NAMI to send us some of those for use locally. So that's another resource. And then also the Minnesota Judicial Branch, I'll go back here under help topics. And then if you click on mental health and civil commitments, there is another screen. There's not a ton of information on here, but there are some of those definitions that Paul discussed. There is an explanation and overview of the process. And then there is a link to one form, not a ton of information. And then there's also a link to the statute that governs the civil commitment process. And then also on this page is that link to the Office of Ombudsman, which I also went over. Does anybody else have any other resources that they would like to share that they're aware of?
Where was the first resource from?
The first resource is from the Ombudsman for Mental Health. And again, I'm going to try to grab the links and share them in the chat. And then I will let Christy know that there's an interest in having those links emailed out in her follow-up email. So we can also include those in the follow-up email.
Great.
Sure. So the first link I'm posting is just the page to the Ombudsman office, and from there you can get to the other resources with the fact sheets and so forth. And then NAMI, I'll give you the link to the civil commitment booklet, but again, there's just a bunch of information on the NAMI website that would likely be of interest to folks who are attending. And then finally, I will post the page to the civil commitment mincourts.gov civil commitment site. So all of those are available and will be provided via email from Christy after the session. And if I can figure out how to stop sharing, I will. Sorry, I'm new to Google Teams. I'm used to something else. Any other questions in the chat or otherwise? I have one question, and this is only because I have experience with this, but
You're still sharing.
I am. I'm sorry. I'm
If you
going to
go
try.
up to the little arrow next to the leave sign,
Okay.
click on that.
Oh, thank you very much. Okay, am I stopped sharing?
You did it.
Thank you so much.
Welcome.
A question for Karen or Tessa or perhaps even Paul, but for someone who is undergoing a civil commitment and taken out of their home for a period of time, what types of services or supports or aid can be accessed for those people to maintain their housing?
Okay, that's a really good question. So I haven't had this happen in quite a while, actually, but as far as I remember, there's crisis housing funds available. So individuals who need to pay rent but are still in the hospital, if their medical assistance is going toward, well, okay, like if they're in a hospital, then their insurance should be paying for that. So they should still be able to pay their rent as needed. If they are living at an IRTS placement, the majority of their Social Security funds goes to pay for that that setting. So that's where the crisis housing funds would be available, and that would pay for, I think, their rent while their Social Security funds go towards the IRTS placement.
And they would connect with the facility in which they have placement at that time to facilitate the crisis housing application. The county is not a partner on that, but where they're at could help them with it. We just can't submit it through the county. There's some different legal language in there and insurances and things like that, where the community partners are better able to do that than the county.
Okay, thank you. Any other questions by anybody who's attending? I want to talk to Paul and ask him a question about neuroleptic medications. If you could talk a little bit about what the procedure is for that.
Yes, I realized while we were talking about the resources, I had forgot to mention that. So neuroleptic medications are medications to help treat the mental illness of individuals. Excuse me. There needs to be a petition filed by the facility and to enable the court to grant the authority to prescribe those administer those medications if the individual is refusing. So if a person is at Winona Health or Mayo and is not willing to take prescribed medications, the facility can file a petition with the court, which is commonly referred to as a Jarvis petition, requesting permission to administer those medications to that individual. There is some limited authority for giving medications on an emergency basis if an emergency exists for extreme safety reasons. Once the petition is filed, there needs to be a hearing within 14 days of that petition. Similar to a commitment petition, there is a court examiner appointed who talks to the individual, reviews records, makes collateral contacts, and makes a recommendation whether they feel that the Jarvis petition should be granted or not. The petition does need to lay out the specific medications. So under Minnesota law, the court is not supposed to just grant blanket authority to administer medications. It's supposed to say, for instance, the facility is authorized to administer Haldol and Zyprexa at these dosage levels. It's not required to include dosage levels, but lots of times judges prefer to include that so to kind of rein in the authority of the hospital or treatment center. It's not uncommon that if a person is in a hospital before the commitment is ordered, that the hospital files a Jarvis petition, and so the Jarvis and commitment can be heard at the same time. And also we get them down the line once they're admitted to a community behavioral health hospital or a care facility. So it can depend, but it's another statutory way to make people come through the court so a judicial officer can review the paperwork and make sure that the medications are legally necessary and get the authority to administer them. Yeah, I think that's what I got about Jarvis. If there's anyone has more specific questions, I can certainly answer those.
Okay, thank you, Paul. Any other questions by anyone or anything else that Tessa or Karen or Paul want to add?
Did we want to touch on how pre-petition screening happens when there's a Rule 20 and what is a Rule 20?
Sure, that's a Paul question, I think.
So I can start, and I think Karen and Tessa probably have some good information too. But a Rule 20 is in a criminal case when there's concerns whether the defendant is competent to assist in his or her own defense. So there's Rule 2001, 2002, and 2004. For commitment purposes, a 2004 is, so 2001, from my understanding, is for competency. 2002 is whether if the individual wants to raise mental illness as a defense to the charged crime. Then a 2004 is essentially an examination whether the examiner under the Rule 20 feels that a commitment is appropriate or necessary. So the court will grant the Rule 20. Usually those are, in my experience, the court usually doesn't put too much fight toward ordering a Rule 20 evaluation. Then the examiner or evaluator files the reports with the court. Copies are sent to the county attorney's office and to the defense counsel. And then if there's a Rule 2004 that says this person meets the criteria for civil commitment, the court is supposed to direct, and for Winona County Health and Human Services, to conduct a PPS investigation. We try to get a court order saying, because of the sensitive nature of a Rule 20 evaluation, we try to get a court order saying, yes, send those over before we actually provide the Rule 20 to Human Services, just to make sure that a person's privacy and rights are protected. So then it gets sent over to Human Services, and they kind of do the similar investigation, whether a commitment is appropriate.
So the Rule 20 recommendations will come to us, and it is recommending that we screen the person to see if they meet the criteria for civil commitment. A Rule 20 in and of itself, as Paul said, cannot cause the person to be automatically civilly committed. It is saying that a pre-petition screening should meet with this individual to assess, do they meet that level of need for support. So again, it's that same process. We receive the intake either from the court administration office, county attorney's office. We've had attorneys send it to us. So we receive that Rule 20 recommendation for a PPS to commence, for the pre-petition screening team to commence with their interview of the individual. And then it's the same process that we've already gone through. It's just another way that it might be received, and doesn't necessarily first come through our intake, but comes through the courts and that a process that was asked for the assessment of that individual with that Rule 20.
And I'll add, kind of related to a Rule 20, but not directly, is that the statutes require that if a person goes to trial and is found to be not guilty by reason of mental illness, there is certain requirements for the county to consider, I think it's technically the county attorney's office, to consider whether a commitment should be brought. That's a very specific situation if the person's found not guilty by reason of mental illness.
Okay, thank you. Any last questions?
This is Sharon from Houston County. In Winona County, who supervises and makes the report to court for the Rule 20s?
In Winona County, that is not a requirement. That is unique to Houston County.
Meaning?
Just meaning that that is not a requirement in Winona County. We report our findings to our county attorney. County attorney communicates them to the court. There's no ongoing supervision of that person.
Thanks.
Yep.
Any other questions? Anything that any of our speakers would like to say as kind of a last statement or summation or anything regarding the civil commitment process?
I'll just say there's a lot of information in any presentation. If anyone on this meeting wants further information or has a question, feel free to reach out to me. I'm a resource, maybe not be able to answer anything, but I can probably point you in the right direction. But feel free to contact me if you have other questions that come up later on about the commitment process.
And Paul, perhaps you can email your contact information to Christy, who will be sending out a post-training email. I emailed her with the links that we had provided. Looks like maybe she's back. Christy, are you back? You want to take over?
We lost her.
We lost Christy. Okay, well, we're going to wrap it up. We're going to give you an hour back of your time. Thanks to everyone for attending. A special thanks to our speakers, Paul Ellison, Tessa Loken, and Karen Bankowski. We do appreciate your time and expertise. And stay tuned for additional trainings that will be offered through the RAP Plus grant. So have a good afternoon.
Thank you.
Thank you.